Lordships will remember that I made a very narrow argument, which was I looked at 4 or 5 sections, read the sections.
Yeah, well, you have to prima facie convince us that it is so.
Yes, exactly. So I'm going to do that, Mullahs. And Mullahs, kindly just keep one thing in mind. A section cannot be read in the context of what is set out in the counter affidavit.
Yes.
Nor it can be read on the basis of what written submissions have been made. You have to see the section on its own terms. Right, Mullahs? Therefore, let's see 3C, so that we just analyze the section. My learned friend said, all that 3C does is to change the revenue entry. It changes the revenue entry. I continue to be in occupation. I will not be evicted. I'll continue to be in occupation. And we don't determine any substantive right. The title remains with me. That's what he said. Now let's read 3C. Deals with only government property. Any government property identified or declared as waqf property before or after the commencement of this act shall not be deemed to be waqf property. That's a declaration. If any question arises as to whether such property is government property, the state may, by notification, designate an officer above the rank of a collector who shall conduct an inquiry as per law and determine whether such property is a government property or not and submit his report to the state government. So he has to make a determination. What is the determination that he makes? That this is government property. Obvious, Mullah, from the plain language. So he has to first determine that it is government property. Then it says, provided that no such property shall be treated as waqf property till the designated officer submits his report. So 2 propositions arise from there. Proposition number 1, before he determines anything, before he inquires into anything, it shall not deem to be a waqf. Under what principle of law can that be substantiated and upheld? Which principle of law? Before you start an inquiry, on the basis of any question that may arise, the question will arise in your mind, or somebody files an application, and the moment that question arises, till such time as he submits a report, what report? That it is government property. Determine. It's not a waqf. So under which principle of law can this be sustained? Not his counter affidavit, nor his written submissions, nor his saying title remains with me, possession remains with me, I cannot be evicted. Where did he get from the statute? It's not there in the statute. You have to read the statute. There are judgments of this court say, read the language of the statute and interpret the language. So point number 1, the declaration that it's deemed to be treated as waqf property till he submits his report without any basis because there is a question that has arisen is per se unconstitutional. Per se unconstitutional. And he has not answered that. And there is no time limit as to when he is to submit his report. So it will be treated as not as waqf property, no time limit, no inquiry, it's before inquiry. That's point number 1. Point number 2.
That means it is after the inquiry starts,
yes,
but prior to the report.
Yes. So, Mullahs, he may take 6 months, he may take 1 year. So I have lost my right as the community has lost its right as a waqf. If you don't, will you allow me, sir? I did not interrupt you for a minute. I request my learned friend not to do so. But that's, you sighed, let me say. And rightly so. So, Mullahs, that's the point. Point number 2. What does he have to determine? That this is government property. As your lordship knows, Mullahs, the revenue entry will only be changed once you have determined your title. Can't be changed just like that. I am in possession. Take a normal suit. I am in possession in that property. Revenue entry is in somebody else's name. He'll have to file a suit. That look, I'm in wrongful possession. This property belongs to me. The revenue entry is mine. I don't have to go to court. He has to go to court. So, Mullahs, therefore, the determination that is government property is determined by him. None of this is pay me. It's behind my back. There is no procedure. So the point number 2, there is no procedure established here as to how this determination is going to take place. Which law is going to be followed? Which is that procedure? Ex facie arbitrary. No procedure prescribed. He says inquiry as per law. What's the law? 83. So he has to go to court. Then why the designated officer? There is no other law. In this statute, Mullahs, other than 83, there is no other law. So as per law, if you interpret it to 83, he has to go to court before that determination. And other than that, there is no other procedure. Kindly see, it's very interesting. 83 says, if any aggrieved party, subsection 2, any mutawalli person interested in a waqf or any other person aggrieved by an order made under this act or rules, any other person aggrieved by an order made under this act or the rules may make an application within the time specified, and there also no such time is specified within such time as may be prescribed. This is the only mode. There is no other law. And the expression law in subsection 2 is as vague as it can be because we don't know what that law is. Now the counter affidavit says, no, sir, but you will be heard. Very good. So now the counter affidavit will decide what that procedure will be. The statute will not. How does the title remain with me, Mala? As he said, he's already determined. That's after he gives the report. I'm not. Before that, I've already made my submission. He's already determined that this is government property. Then only will the revenue entry be changed, Malaj, because it's sequential. After determination, in case the designating officer determines the property to be government property, he shall make necessary corrections. So the corrections can't be made till he determines it's government property. Therefore, Malaj, it's not just a revenue record change, which is the basis of his argument under 3C. Then how does he say? It's just a change of revenue record. And what's the explanation for this, Mullah? None. And it's irreversible, Mullah. Irreversible. The right of the community is taken away merely because there is a question that arises. Right, Mullah? And this particular section relates only to government property. I made these submissions, Mullah, earlier, not answered. Answered by the counter affidavit, but I say the title will remain his, possession will be his, he can't be evicted. Why? Who says that? Now, Mullah, kindly see the definition of, in 3R, the proviso, which we've been reading. So now I've dealt with government property. Let's be dealing with something else, which is much worse. No, not use it. No, I'm just saying something else. Kindly see. See, the waqif means any person making such dedication.
So three?
The 3R proviso. May I read it? My lords, much as much here. Provided that the existing waqf-by-user properties, registered on or before the commencement of this Act of 2025 as waqf-by-user, will remain as waqf properties, except that the property wholly or in part is in dispute or is a government property. So if you take the government property, waqf as user, that 3C will apply. And the same
If you would apply,
is government property.
while determination.
Sorry?
If the collector initiates process for determination,
Yes.
then only 3R would.
Yes, so it says now, except property wholly or in part in dispute or is a government property.
Somebody will have to claim that it is a government property.
That's correct. Who will claim? Not I.
The government is.
Yes. And how will he claim? By going to the tribunal? Because I am occupying it. I take example, but a simple thing. I am very simple. I have a burial ground. It's remained there for 200 years. There are so many burial grounds in this country who were there for 200 years. Now, we don't know how it happened to be that, but burial is an essential part, is integral to the Islam, right? After 200 years, the government says, no, this is my property. Can burial grounds be taken over for?
But if you have registered, if you scheme the Act from 1923, or 1923, though technically you may be right that there was no provision for registration technically, but the information was required to be given to the authority. And then from 19...
Information to the court.
Whether we don't compete with that young...
Yes and no, I'll...
Then...
Absolutely.
Continuously from 1954, the registration is required, and the 1976 report also, yes, we can read that report as to why registration was found to be.
I am at one.
It is not as if that from 1923 till 2025, over a period of 100 and odd years, if the scheme of various enactment has emphasized on a registration, and if somebody has not registered.
Correct. I must answer that. No? I'm going to answer it, and I have a full answer for it.
Because we believe in having an open dialogue.
Correct. I have a full answer because I knew that question will come from your lordship. But at the moment I'm reading the section, I'll answer that immediately. I'm reading the section at the moment. It may not be 100 years old, it may be 3 years old.
3 years old. If it is registered, it will be protected.
But it may not be registered. Waqf-by-user may not be registered. There's a judgment of the Supreme Court, any number of judgments, it need not be registered. That's settled law by the Supreme Court. Settled law. So I'll come to that later, but I know what is in your lordship's mind. That's why I'm not wasting too much time, just going straight to the point. Because I don't want to just dilly-dally.
We must tell you what is in our mind so that we can get the answer.
Absolutely. Now, therefore, let's leave that out for a moment. Waqf-by-user of government property. Come to this, or in part is in dispute. Private person, if it is in dispute, then how is it not waqf? Government property is 3C, but is dispute.
There is no such procedure for any property with regard to private property like 3C.
Yes.
So it's only 83 where the people, if somebody is disputing.
Yes. What will happen is, here the survey is not there now. I'm just giving your lordships an example. There's a private dispute, waqf. to a waqf. Under the law, it's no longer a waqf. Just by this expression is in dispute. At least, Malad, in 3C, there's a determination that it is government property. There is no such determination here. There is no procedure of determination. There is no reference as to how this dispute is going to be determined. There is a declaration by law, by the legislature, that if there is any dispute, it shall not be waqf at all between two private parties. Under which law can this be sustained? Can't be.
Yes.
Now, Your Lordship, very important question. You also said, what is waqf-by-user? I give you a note, because I'm going to answer that question, but Your Lordship has it?
Yeah, can we?
Yes.
Tables up, can we?
Yeah, I was just giving it. No,
We are giving.
one second. Now, just briefly, orally, I'll tell Your Lordships. In the 1954 Act, for the first time, they said, these mutawallis are not the kind of persons who should be handling all this because they won't register in the 23 Act. And then ultimately, Millard, it was decided that there should be a survey. And for the first time, that was decided in 1954. That we now must survey these properties to find out what is waqf and what is not. 54. Then came 1995. And in 1995, there was a whole procedure. Nothing had been done. That's not mutawalli. It's the states who were to survey, not the mutawalli.
That's what Mr. Ravi also said, that his petition is pending from 19. That
No, but I'll show even more egregious, because I'll give you data now. There are only 2 waqfs registered in Delhi.
Serious.
There is 0 waqf registered in Jammu Kashmir. But anyway, that's their data, not mine. But I just point that out as to why this happened. Why this has happened, I'm pointing out. In 1995, there was an elaborated procedure. Like, no, we must go and we must do it very quickly. Nothing done. No state government acted. Then in 2013, they said, okay, you guys have not acted since 1954. Now these surveys must be over in 1 year. I'm answering the question why they were not registered. The argument is they were not registered, so they lose their character as waqf. I am telling Your Lordships why they were not registered. The failure of the state government to not do their job from 1954 to 2025. And that failure, with that failure of the state government, the community is going to be punished because it was not registered. That's the argument. Now just read the note with me, Malaj. It'll all be clear. Malaj, kindly come to Roman 2. That's page 2 of the note. To justify the ouster of unregistered waqf-by-user from the protection of the Act. I'm sorry, Justice Messi has it. Yeah. Page 2, Malaj, on the left-hand side. Roman 2. To justify the ouster of unregistered waqf-by-user from the protection of the Act, the Union contends that there has been a consistently mandated legislative intent of registration for all waqf, including waqf-by-user, since 1923. Exactly what my Lord said to me. And that affording protection to unregistered waqf-by-user puts a premium on those who have been defying the law of the land since more than 100 years. This contention must be rejected. The statutory consequence of non-registration of waqfs under the Acts of 23, 54, 95, 2013 have never taken away the title of the waqf. Mandatory nature of the requirement to furnish details or register the waqf was limited to penalties being visible. This argument we've already made. Well, let's forget this argument for a while. Now come. Statements of objects and reasons of the Mussalman Waqf Act 23 show that the requirement of disclosure of waqf properties to the court was introduced because, in some cases, difficulties have arisen in finding out whether any particular properties are really subject to waqf or not. There are numerous waqf properties all over the country, unknown to the public, which the mutawallis are treating their own private property and dealing with in any way they think fit or necessary. Therefore, it is clear that the evil that the 23 Act sought to remedy was that of unscrupulous mutawallis evading public disclosure to escape accountability. This system was still dependent on the mutawallis voluntarily registering the waqfs. And therefore, the Waqf Act of 54 introduced, now this is the important thing, Section 4 and 5, which required the state to conduct a survey and register waqf properties, thereby placing the onus on state governments to identify waqf properties. This was continued in the Waqf Act of 1995. In addition, Waqf boards were given the power under Section 40 to identify waqf properties which escaped survey, which has been abolished now. Section 40 goes. Now it's with the collector. Survey has been abolished. Well, just look at the egregious nature of this legislation. Despite this, it was noted in the statements of objects and reasons of the Waqf Act of 2013. There is no time limit fixed in the Act for completion of such surveys. So far only one state has completed the survey. Well, this is the most important factual statement. In other words, from 1954 to 2013, only one state had completed the survey. Whose fault is it? Muttawalli's. This is your legislation. And Malaz, how does a person who is enjoying the benefit of the work find out whether it's waqf property? What is this going on? So the community will be deprived because the surveys are not done by the state government, and now you will say because it's not registered, it's not a waqf. This is, Malaz, it's per se expropriatory.
Your responsibility is to register goals.
Back to my submissions. Kindly take Malaz volume 1 of the preliminary counter affidavit that the state government has filed. Just volume 1. Yeah, I'll come to that. I'll show that. Correct.
Yes. Page?
Page Malaz 158. There's a chart, Malaz, your lordships have to turn it around. It says annexure R1.
158.
Yes, 158. Lordship has the chart? Yes. Just an idea, Malaz. In state, for example, Telangana. We know, Malaz, Telangana very well, Malaz, as to how many members of the community live there. Number of properties registered in 2013, zero.
For registration.
Zero.
So nobody went for registration.
If you don't mind, again, will you? I don't know why you are interfering. Why should you? You should not say all this. Worried.
Yeah.
So, Malaz, therefore, zero. Who has not registered them? The survey commissioners, not done their job. And now the 2025 Act says, we didn't do our job, so you've lost your right. That's the law. Is that reasonable? Isn't it per se unconstitutional? No, there are many such instances. Take, for example, Jammu Kashmir 1. Take Delhi Waqf Board 9. Percentage increase 1,153. Obviously, there will be, because you haven't done your job. Third from the bottom, Shia Central Waqf Board, zero. In Uttar Pradesh, zero, Malaz. Imbabara, famous Imbabara, will go. Doesn't exist now. Malaz, just see the serious consequences of all this. And all this, my counter affidavit says this.
Must come in here, Malad.
Please.
My learned friend is saying something fresh.
Give me 1
minute. Give me 1 minute.
No, I'm sorry.
I'm sorry.
Even rejoinder.
Yes, sir.
This is on Vamsi portal.
I'm coming.
Most of the board have not
I'm
updated
sorry.
figures in Vamsi portal.
Why are you interrupting him?
Please allow me to answer.
We did not permit them to.
I did not allow me, Wallace. Allow me. It's not fair. It's not fair at all. You make all kinds of statements and you say, we have misled the court. Every time, Wallace, every other half an hour, you would say, I'm sorry to say they misled the court.
But then there are also states where.
No, kindly see the second column.
Mehta, please, please control yourself. We are telling you time and again that don't try to compute it that young girl assisting Mr. Sibal and disturbing him.
I'm not saying no, but Malaz, the question is, and see the last report.
But you see there are states wherein,
Therefore, there may be many more. Malaz, I'm pointing.
Tamil Nadu is, Tamil Nadu, Punjab,
Maharashtra, 50,000.
Maharashtra.
Yeah, but there may be many more.
Kerala.
Malaz, works are all over the state, all over the country. And those may be voluntary registrations because only one state had done. Kindly see the latest Malaz, Vamsi report at page 63 of the rejoinder affidavit. Or my rejoinder, 276 of 2025. I mean, this is shocking.
This is as of 2000.
And this is also 2013, Malaj, as of 2013. Sorry. It is a rejoinder affidavit 276 of 2025 lead matter, page 63. Because I need to finish because others have to speak. Malaj, therefore
So therefore we are not interrupting you much.
And you are not, Malad. I'm just saying. I'm trying to be be fast and not going to all the other issues.
Because we have to conclude.
You have been very kind, Malad. Yes.
I think there has been least interruption from.
That's true. That is true.
Unless it was.
Well, we cannot blame you for that, Malad.
Unless it was really necessary.
And then on this chart, they have themselves made submission at page 7 of the counter. They have themselves made this submission, saying that, look, our people did not work. We'll come back? Okay. Now we'll come back.
Yes, we can proceed and ask someone to find it out.
Okay, Maras. All right. While they find it. Now, Maras, kindly see.
We have to conclude.
Yes, before we'll conclude, Maras. No issue at all. Because now, Maras, kindly read one judgment of Justice Fazal Ali Give me that judgment.
2 hours in the Jordan? Both of these.
It's here.
What side we curtailed me not 2 hours in the Jordan?
Childish. Now, this is 1976 4 SCC, page 780.
1976,
1976 4 SCC 780, para 36 and 39. Yes. Now, can you see? Yes, 36 and 39.
480, 36, 59. निकालें फोन में मैं भी इसमें निकालता हूँ
At page 803, starts at 780, at 803, para 36.
जीरो नहीं हो सकता
Page 603.
yes,
Amir Ali, in his book Mohammedan Law, has given several instances of a complete and irrevocable dedication made by the Waqf for the founder and the consequences flowing from the same. Amir Ali observed as follows: the proprietary right of the Waqf is a building or ground set apart for prayers becomes extinguished either on the declaration of the Waqf that he has constituted is as a mosque or a musalla, or consecrated it for worship, or on the performance of prayers therein on thereon. Thus, the moment a building is set apart for offering prayers, the proprietary right of the Waqf is completely extinguished. Similarly, the following observations of the author indicate the various contingencies in which a dedication can be made to a public mosque. Kindly see, Mullahs, the second paragraph. When a mosque is erected, that one. When a mosque is erected or set up inside a dwelling house, a residence, and permission is granted to the public to come and pray, and a pathway is also made or set apart for their egress and ingress, the dedication is good by general consensus. If a pathway is not indicated in that case, according to Abu Hanifa, the dedication is not sufficient. But according to Abu Yusuf and Muhammad, it is good, and the pathway will be implied by the permission to pray, and this is correct. Now the last two paragraphs. If prayers are offered once in a mosque, it is difficult to constitute a good dedication. According to Qazi Khan, the delivery of possession as regards the masjid is complete when one person is prayed in it, and azan and his iqamat. The view universally adopted is that prayers offered by one person in a mosque is sufficient to constitute it as a public mosque devoted to the worship of God. For a mosque belongs to the deity, and there affixes to it a right of the Muslims in general, and one person can be a proxy for the establishment of the right of the Creator and the public. Therefore, if a person creates a mosque and gives permission to people to pray therein, it is an absolute waqf, and this opinion we adopt. Now, the observations of the learned author are based on Radul Mukhtar and other original religious books which contain law on the subject.
So no difficulty on this. Even the Privy Council, on which Mr. Dwivedi
Yes.
relied,
Right.
also says that the land which was permitted by Hindu zamindar
Correct.
To be constructed for mosque,
Yes.
and by prescription,
Yes.
though there was no written document or something,
Correct.
but long user made it.
That's precisely the point, Mullah. So long user will make it a waqf.
Yeah, but if suppose on a government property.
No, government property also. I'll give you a an example. But we have several examples. I can say so myself. What happens is that a community goes to the government and says, we need a burial ground. We need a burial ground. We don't have any. So, in fact, the government itself allots it. I know for a fact.
Yes.
And it is used for 100, 200 years. No limitation will apply to them. After 200 years, they'll say, no, this is our property. We'll build a commercial complex on it. What will happen? Because the moment it is used as a burial ground, it's a religious activity in Noida. So, the point is not that.
Everywhere it is, at every place.
Correct. And Mullah, these are not
Sometimes.
sometimes.
I don't think that the government is a.
Yes. No, it can be government, it may not be government.
Then at all such cases, I think most of them must have registered themselves as a.
No, but that is what these are not isolated. I'm talking about hundreds of properties all over the country. Nobody would know till you do a survey. And who is, I can't, Mullah, supposing I'm a devotee. How will I know? I will not know. Nawazi will also not know. Namazi Mullah, he will also not know. He will also know he's offering prayer only. All the records are not with us. There are 39, para 39, read this, Mullah. It's very important. So, point is, you can't by legislative fiat just extinguish everything. 39. It would thus appear that in order to create a valid dedication of a public nature, the following conditions must be satisfied. That the founder must declare his intention to dedicate a property for the purpose of a mosque. No particular form of declaration is necessary. The declaration can be presumed from the conduct of the founder, either express or implied. That the founder must divest himself completely from the ownership of the property. The divestment can be inferred from the fact that he had delivered possession to the mutawalli or an imam of the mosque. Even if there is no actual delivery of possession, the mere fact that members of the Mohammedan public are permitted to offer prayers with azan and iqamat, the waqf is complete and irrevocable. And
that's what the Privy Council also.
correct. So, Manoj,
Even the provisions of the law,
correct.
which have been taken to us, they also say that not only documents but other things other particulars could have been provided
Correct.
for registration.
And the point I'm making is, if I have used this now for 100 years, 200 years, 50 years, and this is my religious activity, then how can they take it back? Limitation has to apply also. There is no limitation that applies to them. They can take it at any point in time because they say this is my property under 3C.
Yes, we'll consider that.
Yes, so very, very serious consequences. Now, I want to show I was in para 8 of the note. If you also don't mind. By page 3, para 8. Despite this, it was noted in the statements of objects and reasons of the Waqf of 2013, there is no time limit fixed in the Act for completion of such surveys. So far, only one state has completed the survey. This survey was still not being carried out by some state governments, such as Gujarat and Uttarakhand. Even now, this is 2025. So there is no Waqf in Gujarat and there is no Waqf in Uttarakhand. Is that the argument? And because it is not registered, they'll all be taken away by the government? Yes.
Please maintain your cool. If you want, we'll increase or decrease the temperature.
Then he says, it is therefore clear that non-registration of Waqf properties that have continued unregistered is partly on account of their own unscrupulous mutawallis and more prominently on account of the failure of the state governments to conduct a survey as mandated by the Act. Despite a lapse of 17 years since this mandatory obligation was imposed on state governments. Your Lordship asked me the question, I told you, Mother, I have an answer to it. And this is the answer. This is a state responsibility by statute, which they accept they did not discharge. And then they say, because we did not discharge our responsibility, therefore, if it is not registered, you have no right. Unacceptable proposition of law. You can't take advantage of your own wrong through a legislative fiat. Then the argument that unregistered waqfs by user can now be excluded. Unregistered waqfs by user can now be excluded as over time of over 100 years to register waqfs amounts to punishing the larger Muslim community, the beneficiaries of a waqf, for its failure of the state government. Naturally, a number of waqfs by user do not have appointed mutawallis, since the original instructions of the waqf are no longer known, and hence there would be no person who can be charged with the primary responsibility of registering the waqf. It is also meaningless to argue that individual beneficiaries of a waqf can also file an application for registration. Beneficiaries of the waqf, such as namazis in a masjid or zareen in a dargah, are merely visitors and will typically not be aware of the registration status of that place of worship and cannot be saddled. Suddenly they won't be able to go. It is for this reason that both times that a proposal was introduced to deny legal protection to waqfs for failure to register, and the same was omitted on the opposition of the Muslim community. My learned friend made a point of that. Who opposed? Of course they would oppose. They were being punished for the state's wrong, Malaj. This is seen in the non-implementation of the proposed Section 55E, Malaj, which he pointed out, sought to be introduced in the Waqf Amendment Act of 84. This can be seen in a statement of objects and reasons of 95, which mentions the provisions of 84 Act could not be enforced because strong opposition to its various provisions came from the Muslim community. The second attempt to introduce such a provision was by way of 87, which was omitted in 2013 due to the opposition. Finally, the contention of the union is based on a fundamental misunderstanding of waqf by user. A waqf by user is not a waqf created by use of non-waqf property as a waqf. Waqf by user is a rule of evidence by which a waqf whose documents on proof of dedication have been lost by passage of time proves that it is a waqf. Depriving a waqf by user status on account of its non-registration or making its status contingent on such registration is directly in the teeth of the Constitution Bench. And so just read 1134 because I don't want to read it, no time. Our jurisprudence recognizes the principle of waqf-by-user, even absent an express deed of dedication or declaration. This is a Constitution Bench judgment. How can the legislature go against that judgment and say there is going to be no waqf-by-user because it's not registered? Whether or not properties are waqf property by long use is a matter of evidence. The test is whether the property has been used for public religious worship by those professing Islamic faith. It's a burial ground or it's a mosque.
Oh, you are saying that there is a direct judgment which says that registration is not necessary.
Yes, there's the Constitution that I showed your lordship. W128 itself says so. 1134 says so. Doctrine of waqf-by-user received judicial recognition. The decision of the Privy Council. Court of Wards of Property. This case concerned a public graveyard in Multan with a prominent Muslim saint was buried. Court of Wards acting with the property so-and-so proposed to sell certain property within the area. Muslim residents sought an injunction restraining proposed sale on the ground that entire graveyard was inalienable due to its long use as a public graveyard. And then 134 says evidence threshold is high. The most cases requiring evidence of public worship of the property is question of is since time immemorial. It was admitted that old mosque was, let's leave that out. So it is itself a rule of evidence. It can't be decided. A rule of evidence cannot be done away by a piece of legislation says we require no evidence, we will make a diktat that if you are not registered, you will not be a waqf. On what basis do you say that?
Yes.
Then, now this takes care of waqf-by-user. Now, have you got that? Have you got that file, please? The WAMC? Just bring, right? Kindly come to 158.
This did see.
You have seen this already. Then, kindly come to page 63 of this rejoinder. It's a WAMC report itself.
2020.
From 2013. Just see the middle,
Page 63.
Yes. This Rahman Khan was a member of the Rajya Sabha with me, and they worked for many, many years on this.
63
Middle of it says state UT waqf boards where WAMC software have been successfully installed. Your Lordship has that?
Your rejoinder. Sir, I have your rejoinder 63 as some paragraph.
No, not rejoinder affidavit.
Rejoinder affidavit.
It's also there.
Rejoinder affidavit filed by Ejaz Makbul.
No.
Rejoinder affidavit on behalf of petitioner.
That's correct.
Yes, that's what we have in response.
Mr. Arshad Madani, not this, please. Allow me. It's all circulate. Anyway, see state UT waqf boards where WAMC, DMS software have been successfully installed are Assam. See that? Then digitation work. It is only installed. The software has only been installed. Now what does it say? Pre-digitization work is in progress. We are on 2013. Pre-digitization work is in progress in all the state UT waqf boards where CCF setup is under development or completed. Once the pre-digitization work is completed in all respects, then an actual digitization work starts. That is, all the ownership establishing documents are scanned next using WAMC and finally imported into WAMC DMS at the present respective premises for searching and retrievals. The state UT waqf boards where digitization is complete is only 4 in this country, in two UTs and Assam and Madhya Pradesh. The digitization work itself was not completed as of 2013. Only one state had conducted a survey and digitization state was completed in only 4. And now you say you did not register, therefore this is not waqf. This is not, at least normal. So therefore, then you come back to the definition which I was reading in that context. Because they say, if it's government property and 3C, then you're out, if it's not registered. This also goes into one of the final argument that he made, that all waqfs that have not been registered therefore are not waqf. So if the whole process, if the registration depended on a process and the process is absent, then the outcome also can't be that the community loses its rights. Cannot be. So I've done with section 3. And I've done with the 3R provider. Yes. Now kindly come with us to 3D. So that's all I have to say on these. Kindly come to 3D. Now, two things on 3D. Point number 1. My learned friend rightly said that a part of 3D was discussed in the JPC, but rejected. Because when the bill came out from the JPC, 3D was not there. And the bill is annexed to the JPC. 994 in their preliminary. In their counter affidavit, page 994, the bill is appended. Yes, as part of the JPC report, volume 2, 2A. To volume 2, yes, page 994. Internal page 828 of the JPC, but otherwise on top right-hand side, 994. Now, at 996 clause 4, sorry, Malaj, I just finished. Give me 5 minutes more. Five minutes more. Huh? You don't need 5-7 minutes more, that's all. Now 994 at 996. And if you see, Malaj, after section 3, that's clause 4 of the Principal Act, the following sections shall be inserted. 3A, 3B, 3C, that's it. No 3D. So the JPC rejected it, didn't include 3D. Even though ASI proposed it, rejected it. That's the JPC's decision. Then it goes to Parliament. This is the proposal. This is the proposal, Malaj. This is the final bill. We are showing what the proposal was. This is the final bill, Malaj. That was the proposal what they showed. This is the final bill. And Malaj, what happened then? Went to Parliament, and then I showed to your lordships how it was introduced. The rule was suspended. It was introduced. So what was not proposed by the JPC was incorporated in the legislation without notice on the day of voting. That's what we told your lordships. Now, how is that, Malaj? Same for 3B, 3E, same for 3E, tribal area, same for 3E. Now, my learned friend says, you know, what, if there's a creditor who wants to recover property, recover property, then that Hindu will say, I give it to the Waqf. That's what he argued, Malaj. So if there is a Muslim creditor, Malaj, then he'll go to and tell a Hindu, you make a temple. So what kind of...
There's no such protection there. There's no such protection there.
No, but the liability will still continue. Only the land is gone. I don't understand what the argument is. How many creditors have come to this court and say they have donated it to the Waqf only to ensure that the money cannot be recovered? What kind of, is this an example that he is giving?
No, this is 1923 the SR of the preamble 1923 Act, which...
But there will be some instances where there will be instituted every religion, but that's not the...
It is not his own argument. It is...
No, I agree. But that can't be the basis of interpreting a statute, Malaj. That may be, Malaj, an inquiry report, but you cannot...
No, but the SORs of the earlier Act, from which this Act flows, can be read while interpreting the statute.
No. See, 3D, just appreciate. What he's saying is the reason why this was incorporated in the statute because people...
Because of the discussion in JPC and because of the ASI making submissions before the JPC.
That's another matter, Malaj. That ASI issue is not... I'm not there, Malaj, at the moment. I'm not...
3D with regard to ASI.
Yes, correct. Now, Malaj, on the 3D issue, kindly read 3D with me now. I'll finish in a few minutes. I just can't... Hold on. Just give me finish. It says, any declaration or notification issued under this Act or under any previous Act in respect of Waqf property shall be void. That's what 3D says. That's not what the Ancient Monuments Preservation Act says. That's not what the Ancient Monuments and Archaeological Sites and Remains Act says. They say the worship will continue. It's only for preservation. So how does it become void? What's the basis of this?
No, but your argument that it will not be permitted, the community would not be permitted to continue their religious practices, that is wrong because that is specifically saved by...
But this overrides that, Malaj, because it's now declared to be void. It ceases to be it says so, it is void. Moment it's a declaration either before or later. It says the declaration made or notification issued or under any previous act in respect of Waqf shall be void. Even under the previous act, Malaj.
No, even if the notification is issued under the
previous act, say 1904 Act.
That act.
Yes.
Then whatever is saved by that act would be applicable.
It can't be because this overrides. This is a later act which says it will be void. ASI is only to permit it to preserve. Yes, for permission.
We'll consider this.
Ownership is lost, Malaj. ASI cannot have title to the property. ASI may permit you to use.
ASI will have a control to protect the
That's right. So they are entitled to, Malaj. They are entitled to. But ownership is still with. Ownership is still with me. All I'm saying is, Malaj, ownership will still be with me. Under this ownership goes. And what's the rationale for that? There's no need for 3D. Because if that was the case, Malaj, that we continue to worship, there was no problem. So why did they introduce 3D?
No, because if you see the submissions of the JPC, before the JPC of ASI, that two parallel things were happening there.
You're right.
Those guides were, guides license were given by ASI. The Mutawallis of the Waqf, they were also parallelly giving licenses.
Correct. So therefore, that has to be stopped. Manoj.
And not permitting them to carry out the preservation and
Yeah, but that,
activities.
in other words, Manoj, if somebody building is unauthorizedly construction, something that is to be stopped. And there are regulatory measures to stop that. But it can't be, Manoj, that you take away my right. The property itself, ownership goes. There's no basis for that. Anyway, Manoj, because the time is short.
Time constraint.
Yeah. Now, Manoj, just two, three broad points and then I've done, Manoj.
Fortunately, we have vacation, but unfortunately, partially working. But unfortunately,
Not partially
we will have this for the vacation.
Manoj, kindly have a look at this. Now, Manoj, I want to explain to you some fundamentals of Islam, Manoj. Some of them I learned from the other side, but some I'm trying to sort of understand myself. Now, Manoj, kindly see my note, paragraph 27.
Spiral.
No, my note, no.
Today's note.
Today's note, page 7. The Union has argued that charity is prescribed by all religions, but is integral to none.
Paragraph.
That is paragraph 27 at page 7. The Union has argued that charity is prescribed by all religions, but is integral to none. And Islam is not unique in this respect. This reveals a complete lack of understanding of Islam. It is well known that charity is one of the 5 fundamental tenets of Islam. Faith in Allah, the Prophet, and His Messenger, namaz, roza, hajj, and zakat for charity. Zakat for charity. But what is this charity for? For the afterlife. Because it's a dedication to God, unlike other charity. Further, the waqf, which is nothing more than a form of continuing charity prescribed by the Prophet himself, is the only tangible means of continuing to accrue spiritual merit even after one's death. Right? It is integral to the religion.
That's integral to almost every religion charity.
No, but they are not charity to God. There's the difference. This is the only religion where you give it permanently. Once a waqf, always a waqf. To God. Dedication to God. No, unlike others. So my learned friend said charity is everywhere. But there's a difference here. Then 2, even where waqfs are dedicated for purposes other, dedication is to God. Whereas charity is to the community. This is a dedication to God. Yeah. Yes.
Dedication to the
Yes, future, Malaj, future. For my spiritual Malaj benefit. Otherwise, after life, once I have done this, I'll be treated better by Allah.
That's what, in Hindus, there is a concept like moksha.
That's right.
Swarg.
That's a Malaj. Moksha, of course, doesn't have. Para 29 members.
We are all striving all
Yes.
to go to heaven.
That's right. That's true. Even where waqfs are dedicated for purposes other than places of worship, such as orphanages, hospitals, educational institutions, the sole purpose of the waqf is to please Allah. As such, waqfs cannot be segregated into secular and religious waqfs, as all waqfs are for spiritual benefit and nothing else. And this is part of my rejoinder, Malaj. And the property is vested in Allah. Property is vested in Allah, unlike others, Malaj. Then other religious endowments, then Malaj, the Union has, now Malaj, last but one point, he says that now I concede that as far as Hindu endowments are concerned, they are both for religious as well as secular purposes. He just said that this morning. Whereas throughout the tenor of the argument is the difference between Hindu endowments and waqf says that's only for religious purposes and this is secular, right? So now, Malas, we are on par. So as far as Hindu endowments are concerned, no non-Hindu. But as far as waqfs are concerned, non-Hindus. Non-Muslims. On what basis? If both are having both religious and secular activities, both should be at par. And they reserve actually for non-Muslims. It's a reservation for non-Muslims. That's given in the statute.
So now you also agree that it is 4.
Yes.
From majority,
Even one is too many, Malas, according to me. Even one is too many. But anyway, be that as it may, Malas. Now, why is this act not fully secular is explained by the act itself. Kindly come to the act. And kindly come to just one section. Section 96.
96.
I'm finishing. There's no time now. Let the others do it. For the purpose, power of central government to regulate secular activities of waqf. So obviously the act itself assumes that there are religious activities and there are secular activities. Otherwise the section would not be there. And what are those secular activities? To lay down general principles and policies of waqf administration insofar as they relate to secular activities. To coordinate and function of the Central Waqf Council and the board insofar as they relate to their secular functions. To review administration of the secular activities generally and to suggest improvements. These are the secular activities, none else. And compare this with 32 minutes. The wide powers of the board, and the board is controlled by them now, nominated by them, And there's no answer for the submission we made that the board was elected through electoral bodies and only Muslims. No answer to that. So why the change? Because you nominate, so you are directly now trying to administer the Waqf. Now, having said that, just read 26 and then I've done with my friends will, yes. In fact, on waqf-by-user, Mr. Dwivedi had given a judgment. Just note the page at 20, it says, in the case of graveyard, it has been held in several cases that long user justifies the inference that the land itself is a dedicated or consecrated property.
That we have noted, that we have.
No, then it itself says that long user would make it a dedicated property. And the next sentence says, or that even if it is not dedicated, it has become Waqf property. That's the judgment that he cited, which goes against him. Doesn't matter, I just point. Now kindly see 26, then I'm done. Now, there's a difference between 25 and 26. 25 says, subject to public order. I'm sorry, the Constitution. That's the last point, my friends will deal with the others. Subject to public order. 25, morality and health, and to other provisions of this part. Now, other provisions of this part is absent in 26. See 26 now. Subject to public order, morality and health, every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purposes. This act is for both for religious and religious and charitable purposes. We have the right to administer. They can't nominate people to manage its own affairs in matters of religion. So on secular activity, you can control us. But as far as religion is concerned, I have to manage my affairs. And rest of part 3 doesn't apply. And my learned friend cited D to administer such property in accordance with law. What law? Subject to public order, morality or health. That's the law. So, it's clear, therefore, that 26 is an absolute right. Waqf is an integral part of our religion. I'm just making the point. I don't want to go to any judgments. And the public, and then 3, the example I was taking about somebody giving away property because he wants to escape creditors was in respect of 3E, not 3D. 3E, because he said that tribals, it's only in that context that he took that. That would apply to any community.
And deletion of 104.
Yes, and deletion of 104. So, what is now left is the collector will do everything. The council will be nominated by them according to us, from the statute. All majority can be non-Muslims. As far as the board is concerned, all of them have to be Muslims through an electoral college. That they've taken away, they'll nominate their own. So it's a direct violation of 26. Direct violation of 26. I'm deeply obliged to you. I'm sorry.
Thank you.
Yes, my learned friend would.
आपके लगातार समर्थन के लिए धन्यवाद दोस्तों। इस वीडियो के कमेंट सेक्शन में अपने विचार जरूर शेयर करें और कानून प्लस चैनल को सब्सक्राइब करना ना भूलें।